Hello Year 12s and welcome to this video on precedent. Last year in Outcome 1 of Unit 1 we looked in some detail at precedent. The purpose of this video is to refresh this information for you. There are three things that you need to do while you're watching this video. The first thing is to take the very best Cornell notes that you can. The second thing is to use the pause and rewind functions. Use the pause function if you need to stop this video to take notes. Use the rewind function if you need to go over any information contained in this video. And the third thing that you need to do is have your vocabulary sheets open in front of you so that you can write into your vocabulary sheets the definitions of key terms and of any other words the meaning of which you're unfamiliar with. Once you've finished watching and taking notes on this video, make sure that you read the pages from the textbook referred to on this slide. And if you find any additional information from that reading that you think is useful, then supplement your Cornell notes with that additional information. Well, let's get started then. Both Parliament and courts make law. The laws that Parliament makes are called statutes, acts of Parliament, or legislation. The primary role of Parliament is to make laws. Courts also make law. The law that courts make is called the common law, also known as case law or judge-made law. Courts can make law when they decide cases. So common law is the law that courts, that is judges, make when they decide cases. Look down the left-hand side of your vocabulary sheets, find the term common law and write this definition in there. So, for example, the law of negligence was largely developed by the courts as they decided cases that were brought before them. This law is that where one person causes loss to another person, that loss was reasonably foreseeable, and the person causing the loss failed to do what a reasonable person would have done to avoid causing that loss, then the person causing the loss will be required to compensate the person suffering that loss. The law about negligence was gradually developed by the courts over around 100 years as they decided cases that were brought before them. Unlike Parliament, the primary role of the courts is not to make laws. Instead, the primary role of the courts is to resolve, that is to decide, disputes by applying existing law to the facts of the case that they are hearing. The courts make law in two ways. The first way in which the courts make law is when they create or modify a precedent, because the case that they are hearing is not covered by an existing precedent. An existing precedent is a law that has been made by a previous court decision. The second way in which the courts make law is by interpreting a statute, that is, a law made by Parliament. A court may need to apply a statute to decide a case that they are hearing, and this may mean that a court must interpret or give meaning to words in that statute. So it's in the course of dealing with a case, that is, resolving a dispute, that a judge can make law. A judge can't simply get out of bed one day and decide to make law. Before a judge can make law, there must be a case brought by a party to the court, and that case must raise a legal issue that needs to be decided by the judge to decide the case. It's only then that the judge can make law by deciding that legal issue. In contrast, Parliament can make a law at any time. It doesn't require a case to be brought before it. As I've just said, one way in which the courts make law is by creating or modifying a precedent. A precedent is the reason for a court decision, otherwise known as the ratio decidendi, which establishes a principle or rule of law that must be followed by other courts lower in the same court hierarchy when deciding future cases that are similar. Look down the left-hand side of your vocabulary sheets, find the term precedent and write this definition in there. Once you've done that, please highlight the words in red, bold, italicized type. And if you're ever required to describe the concept of precedent, make sure that you include those highlighted words in your description. Well, let's unpack this definition a bit further. There are four important parts to this definition of precedent. First, a precedent is the reason for the court's decision, that is, why the court came to its decision. The reason for a court's decision is known as the ratio decidendi. Look down the left-hand side of your vocabulary sheets, find the term ratio decidendi and define this as being the reason or reasons for a court decision. The reasons for a court's decision are distinct from the order that the court makes. So, for example, in a criminal case, the court may decide to sentence an offender to imprisonment. That is the order that the court makes, but it is not the reason for the court's decision. That is, it tells us nothing of why the court reached its decision that the accused should be sentenced to imprisonment in the first place. The second important part of the definition of precedent is that the reason must establish a principle or rule of law. So, for example, in a negligence case, the court may decide that John was driving his car at high speed on a dark and rainy night when he hit Seren. This is not a precedent because this is simply a decision about the facts of a particular case. That John was driving his car at high speed on a dark and rainy night is a fact, not a principle or rule of law. And it is because juries only decide matters of fact, that is, what evidence to believe, whether an accused is guilty or not guilty, whether a defendant is liable or not liable, that juries can never make a precedent. On the other hand, a judge in a negligence case might decide that all car drivers owe a duty to other road users, such as pedestrians, to stop and help them when they see that those other road users have been involved in an accident. That would be a principle or rule of law and so could be a precedent. You'll remember from our work on court hierarchies that one of the grounds on which a party who is dissatisfied with the decision of a court can appeal that decision to a higher court, that is, have that decision reviewed by a higher court, is on a point of law. In such a case, the party is arguing that the court which made the original decision incorrectly applied the law in coming to its decision. It will then be for the higher court to decide what the correct law is. In deciding what the correct law is, that is, in deciding what principle or rule of law should be applied, the higher court will be creating a precedent. This is why we say that precedents are often created by courts when they hear an appeal. The third important part of the definition of precedent is that the principle or rule of law is one that must be followed by other courts lower in the same court hierarchy. You'll recall that a court hierarchy is a ranking of courts according to the seriousness and complexity of the matters they deal with. The highest court in the Victorian court hierarchy is the High Court, which is actually a federal court. There is only one High Court in Australia, and it is the highest court in each of the state court hierarchies. In the Victorian court hierarchy, below the High Court, we have the Court of Appeal and then the Trial Division. These make up the Victorian Supreme Court. Below the Victorian Supreme Court is the County Court, and at the bottom of the Victorian court hierarchy is the Magistrates Court. So, for example, a precedent made by the High Court is binding on each of the other courts in the Victorian court hierarchy because each of these other courts is lower than the High Court in that court hierarchy. The principle that lower courts in the same court hierarchy must follow the reasons for the decisions of higher courts in that court hierarchy is called stare decisis. Look down the left-hand side of your vocabulary sheets, find the term stare decisis and write this definition in there. Finally, the fourth important part of the definition of precedent is that the principle or rule of law must be followed by a lower court where the case in which the principle or rule of law was made and the case which is being decided by the lower court have similar facts. More specifically, the material facts of the two cases must be the same. This is because although the facts of the case are not the precedent, they are relevant to understanding when the precedent applies. For example, in Donoghue and Stevenson, that is the snail in the bottle case, the material fact was that Miss Donoghue could not have checked whether the ginger beer she was drinking was contaminated. This is because she could not see inside the bottle. The bottle was made of dark glass. It was because of this fact that the House of Lords decided that the person who made the ginger beer, that is Stevenson, owed a duty of care to Miss Donoghue to take reasonable steps to ensure that the ginger beer was not contaminated. Put another way, if Miss Donoghue could have checked whether the ginger beer she was drinking was contaminated, for example, because the ginger beer bottle was transparent, then the House of Lords would have decided that the person who made the ginger beer did not owe Miss Donoghue a duty of care, because she would have been able to check the ginger beer herself. In Donoghue and Stevenson, the precedent, that is the principle or rule of law, is that a manufacturer of a product owes a duty of care to a person who uses their product to take reasonable steps to ensure that the product is not contaminated where the customer cannot check the product themselves. Whether or not the customer in a particular case could check the product is a material fact in the sense that the precedent established in Donoghue and Stevenson will only apply where the customer cannot check the product and will not apply where the customer can check the product. There are two advantages of the doctrine, that is, the rules of precedent. The first advantage of the doctrine of precedent is that the doctrine of precedent creates consistency. This means that it ensures that similar cases are decided in a similar manner.
So, for example, it might be that a court has created a precedent that a toy maker is liable in negligence if they manufacture toys for young children, and it's easy for those children to break off parts of the toy and put it in their mouth so that they choke. What that means then is that in all subsequent cases where a child chokes because they're able to break off a part of a toy and put that in their mouth, then in those cases, similarly, the young child, should be entitled to compensation. That's a matter of treating similar cases similarly.
The second advantage of the doctrine of precedent is that it creates predictability.
That is, if a new case is similar to a case that has set a precedent, then the lawyers for the parties are able to advise their clients that the new case is likely to be decided in accordance with the precedent that's already been established. This means that the parties are able to avoid the expense and time of fighting a court case where the issue has already been decided in a previous court case. So in that kind of a situation, the parties are more likely to agree to settle their dispute without going to a court, and they'll settle it in accordance with the previously established precedent.
There are two types of precedents. These are binding precedents and persuasive precedents. A binding precedent is a precedent that a court must follow. More specifically, a precedent is a binding precedent for a court when deciding a case if that precedent is made by a higher court in the same court hierarchy and the material facts of the two cases are the same. Look down the left-hand side of your vocabulary sheets, find the term binding precedent and write this definition in there. As you can see, there are three conditions that have to be satisfied before a precedent is binding on a court. First, the precedent must be set by a court that is in the same court hierarchy. Second, the court that set the precedent must be a higher court in that court hierarchy. And third, the material facts of the two cases, that is, of the case that set the precedent and of the case that is now being decided by the court, those material facts must be the same. So, for example, assume that the High Court set a precedent in a decision it made in 2003, and that in 2020 the Trial Division is deciding a case with the same material facts to the case decided by the High Court. In this situation, the precedent set by the High Court in the 2003 case will be a binding precedent for the Trial Division when deciding the case in 2020. That is, the Trial Division must apply the High Court precedent. This is because, first, the High Court and the Trial Division are in the same court hierarchy, that is, the Victorian court hierarchy. Second, the High Court is a higher court in that court hierarchy than the Trial Division. And third, the material facts of the High Court case and of the case being decided by the Trial Division are the same. On the other hand, a precedent is a persuasive precedent for a court if that precedent is not binding on that court, but is nevertheless relevant to the case and is an important statement of law. Look down the left-hand side of your vocabulary sheets, find the term persuasive precedent and write this definition in there. Put simply, a persuasive precedent is a precedent that is not a binding precedent for a court. Where a precedent is persuasive, a court may choose to follow that precedent, but it is not obliged or required to follow that precedent. There are 4 circumstances in which a precedent will be a persuasive precedent for a court. First, where the precedent is a decision of a court in another court hierarchy. Second, where the precedent is a decision of a lower court in the same court hierarchy. Third, where the precedent is a previous decision of the same court. And fourth, where the precedent is obiter dictum of any court. Include these 4 circumstances in your definition of persuasive precedent in your vocabulary sheets. The fourth situation in which a precedent will be a persuasive precedent is where the precedent is obiter dictum. Obiter dictum, sometimes just referred to as obiter, is a statement of considered opinion on a matter that is not necessary to the decision in the case. That is, obiter dictum is a statement that is not part of the ratio decidendi, and therefore it cannot create a binding precedent. Look down the left-hand side of your vocabulary sheets, find the term obiter dictum and include this definition in there. I'll briefly illustrate each of these 4 circumstances in which a precedent is a persuasive precedent in the following slides.
The first situation where a precedent is a persuasive precedent for a court is where the precedent is established by a court in a different court hierarchy. So, for example, if a precedent is established by a court outside the Victorian court hierarchy, such as where it is established by the Supreme Court of New South Wales, which is part of the New South Wales court hierarchy,
or where it is established by the United Kingdom Supreme Court, which is the top court in the United Kingdom court hierarchy,
then that precedent can only be persuasive on any court in the Victorian court hierarchy. It doesn't matter whether that court is the Court of Appeal, as here, whether it's the highest court, that is the High Court, or whether it is the lowest court, that is the Magistrates' Court. Because the precedent is established by a court outside the Victorian court hierarchy, it cannot be binding on any court in that hierarchy, and so it must be a persuasive precedent. The second situation where a precedent is a persuasive precedent for a court is where the precedent is established by a court that is in the same court hierarchy as that court, but where the court that establishes the precedent is lower in that court hierarchy. So, for example, if a precedent is established by the Court of Appeal, then that precedent can only be a persuasive precedent for the High Court. This is because the High Court is higher up in the Victorian court hierarchy than the Court of Appeal. And so a precedent established by the Court of Appeal cannot be binding on the High Court. It can only be a persuasive precedent for the High Court. In such a case, the High Court can choose to adopt or follow that precedent, but it doesn't have to do so. This is very different from a binding precedent. If the precedent was set by the High Court of Australia, then all of the lower courts would be bound by that precedent. But here we're talking about a case where a precedent is set by a court that is lower in the court hierarchy. And in that case, that precedent can only be a persuasive precedent for all of the courts that are above that court in the hierarchy. The third situation where a precedent is a persuasive precedent for a court is where the precedent is established by that same court in a previous decision. A court is not bound by its previous decisions. This is because for a precedent to be binding on a court, the precedent must be made by a court that is in the same court hierarchy and that is higher up in that court hierarchy. If the Court of Appeal establishes a precedent in a decision that it makes in 2003, then that precedent is not binding on the Court of Appeal, that is the same court, when it comes to decide a similar case in 2017. The reason for this is that the 2003 precedent is not made by a higher court. It's just made by the same court, only earlier in time. However, courts generally follow their previous decisions because this ensures consistency and predictability. The fourth and final situation in which a precedent is a persuasive precedent for a court is where the precedent takes the form of obiter dictum or obiter.
As we've already seen,
Obiter dictum or obiter is a statement of considered opinion on a matter that is not necessary to the decision in the case. Importantly, obiter dicta is not part of the ratio decidendi of a case. Remember that the ratio decidendi is the reasons for the decision of the court in a particular case. And these reasons are the part of the court decision that can be binding. That is, they can be binding on a lower court in the same court hierarchy. However, because obiter dicta is not part of the reasons for the court's decision, that is, it's not part of the ratio decidendi, then it can only ever be a persuasive precedent. Put another way, the obiter dictum of any court, whether it is a statement made by a higher or lower court in the same court hierarchy, a statement made by the same court in a previous decision, or a statement made by a court in a different court hierarchy, that statement, that obiter dictum, can only ever be a persuasive precedent.
we now come to the circumstances in which a lower court can avoid a precedent that is otherwise binding on it. That is, the circumstances in which a lower court in a court hierarchy can avoid applying a precedent that has been made by a higher court in that same court hierarchy. There are three circumstances in which a lower court can avoid a precedent that is otherwise binding on it. First, a court can avoid a binding precedent if it can distinguish that precedent because the material facts of the case in which the precedent was set and the material facts of the case that is being decided by the court are different. Second, a court can avoid a binding precedent if that precedent has been overruled in a later case. And third, a court can avoid a binding precedent if that precedent has been reversed on an appeal. When you're describing each of these circumstances, make sure that you include the words that are highlighted in italics in your description of those circumstances. Let's look at each of these circumstances in a bit more detail.
The first way in which a court can avoid or get around a precedent that would otherwise be binding on it is if the court can distinguish the precedent on the basis that one or more material facts of the decision in which the precedent was established are not present in the case before the court.
As we've seen, the material facts of a case are those facts that are essential to the court's decision in that case. That is, if those facts were not present, then the court would have decided the case in a different way.
Let's suppose that the High Court made a decision in 2003 and that the Court of Appeal, which as you'll remember is part of the Victorian Supreme Court, imagine that the Court of Appeal is deciding a case in 2017. The question for the Court of Appeal is whether it is bound by the precedent established by the High Court's decision in 2003. Now, if the material facts of the two cases are different, that is, if the material facts of the case before the High Court in 2003 are different from the material facts of the case before the Court of Appeal in 2017, then the Court of Appeal is not bound to follow the High Court's decision when the Court of Appeal is deciding its case in 2017. If the material facts are different, then the Court of Appeal is able to distinguish, that is, say there is a relevant difference between the decision of the High Court in 2003 and the decision that the Court of Appeal has to make in 2017.
Look down the left-hand side of your vocabulary sheets, find the term distinguish and include a description of this term based on the description in this slide in your vocabulary sheets. Make sure that you include the words material facts in your description.
The second way in which a court can avoid or get around a precedent that would otherwise be binding on it is if that precedent has been overruled by a court that is higher in the court hierarchy than the court which established the precedent. In such a case, courts which are lower than the court that established the precedent are no longer bound to follow it, because that precedent has been overruled, that is overturned, by an even higher court. Instead, courts that are lower than the court that overruled the precedent must now follow the precedent set by that court. That's a lot of words, so let me try and simplify this for you with an example. Let's suppose that the Court of Appeal made a decision in 2003 and that the trial division, which is lower in the court hierarchy than the Court of Appeal, is deciding a case in 2017. Let's also suppose that in 2010 the High Court overruled the precedent established by the Court of Appeal in the case in 2003. This means that the High Court decided that the precedent established by the Court of Appeal in 2003 is not correct, and so it overturned, or as we say, it overruled that precedent. In such a case, the result of the 2003 case is not changed as far as the parties are concerned, because that case was heard and decided a long time ago in 2003. It's over and done with. However, it does mean that from the time of the High Court's decision in 2010, the precedent established by the Court of Appeal in 2003 no longer applies. Instead, the precedent established by the High Court in 2010 applies. What this means for the trial division when it decides its case in 2017 is that the trial division is not bound by the precedent established by the Court of Appeal in 2003. This is because that precedent has been overturned or overruled by a court that is higher than the Court of Appeal, that is the High Court. Instead, the trial division is bound by the precedent established by the High Court when it overruled the Court of Appeal precedent in 2010. In overruling the Court of Appeal precedent, the High Court would have given reasons for deciding that the Court of Appeal precedent is incorrect, and the High Court would also have decided what the correct legal rule is. It is this new legal rule that makes up the precedent in the High Court case, and it is this precedent which is now binding on the Trial Division when it decides its case in 2017.
Look down the left-hand side of your vocabulary sheets, find the term overrule, and include a description of this term based on the description in this slide in your vocabulary sheets. Make sure that you include the words later case in your description.
The third way in which a court can avoid or get around a precedent that would otherwise be binding on it is if that precedent has been reversed by a court on appeal. Let's look at an example. Let's suppose that the Court of Appeal made a decision in 2003 and that the Trial Division of the Supreme Court, which is lower in the court hierarchy than the Court of Appeal, is deciding a case in 2017. Let's also suppose that one of the parties to the case that was heard by the Court of Appeal in 2003 is dissatisfied with the Court of Appeal's decision and so appeals that decision to the High Court. Generally speaking, if a party is dissatisfied with the court's decision, it can have that decision reviewed by the court that is next highest in the court hierarchy. This is called an appeal. In this case, the High Court is the next highest court above the Court of Appeal, and so a party that is dissatisfied with a decision by the Court of Appeal can appeal that decision to, that is, have that decision reviewed by, the High Court.
Let's now suppose that after hearing the appeal in 2004, the High Court decides that the decision of the Court of Appeal is incorrect.
In that case, the High Court will reverse, that is, overturn, the Court of Appeal's decision, and the effect of this is that the precedent established by the Court of Appeal in 2003 no longer applies. Instead, the precedent established by the High Court when it reverses the Court of Appeal's decision applies. What this means for the Trial Division when it decides its case in 2017 is that the Trial Division is not bound by the precedent established by the Court of Appeal. This is because that precedent has been overturned, that is reversed, on appeal to the High Court, which is a court that is higher than the Court of Appeal.
Instead, the Trial Division is bound by the precedent established by the High Court
when it reversed the Court of Appeal's decision. In reversing the Court of Appeal's decision, the High Court would have given reasons for deciding that the Court of Appeal's decision is incorrect. And the High Court will also have decided what the correct legal rule is. It is this new legal rule that makes up the precedent in the High Court case. And it is this precedent which is binding on the Trial Division when it comes to decide its case in 2017. Now, can you see the difference between overruling and reversing? We looked at overruling in the previous slide, and we've just looked at reversing. The difference is that when a court is reversing a decision, it is overturning that decision on an appeal from the court that made the decision to the court that reverses the decision. That is, both of these courts are deciding the same case. However, when a court is overruling a decision, it is overturning a decision by a lower court in a different case. This is not a situation where that case has been appealed from the lower court to the higher court. It is a situation where the higher court, in the course of making a decision, looks back to a previous case decided by a lower court and decides that the decision of the lower court is not correct.
Look down the left-hand side of your vocabulary sheets, find the term reverse, and include a description of this term based on the description in this slide in your vocabulary sheets. Make sure that you include the word appeal in your description.
This brings us to the concept of disapproving. Most importantly, disapproving is not a way in which a court can avoid a precedent that is binding on it. Disapproving occurs where a lower court states that it does not agree with a precedent established by a higher court in the same court hierarchy. Where a lower court states that it does not agree with such a precedent, the lower court is said to disapprove of that precedent. However, because the precedent is established by a higher court in the same court hierarchy, the lower court is still bound to follow that precedent because the precedent is binding on it. In such a case, the disapproval is obiter dictum of the lower court. It is the court's opinion that the precedent is wrong, but this opinion is not part of the ratio decidendi because the court must apply the previously existing precedent.
Look down the left-hand side of your vocabulary sheets, find the term disapprove, and include a description of this term based on the description in this slide in your vocabulary sheets. Well, that brings us to the end of this refresher on precedent. The information contained in this video will help you to address one of the key knowledge points in this outcome, which is to be able to discuss the factors that affect the ability of the courts to make law, including the doctrine of precedent. Now make sure that you read the pages from the textbook referred to on the first slide. And if you find any additional information from that reading that you think is useful, then supplement your Cornell notes with that additional information. Thank you for your attention.